This moment wasn't about one man. It was about whether the government can ignore a unanimous Supreme Court ruling, rebrand due process as terrorist sympathy, and still claim to be upholding the Constitution. Watch this closely.
Senator Van Hollen.
Thank you. Thank you, Madam Chairman. Madam Secretary, it's good to see you.
Good to see you, too.
And I was glad to see in your recent testimony that you reaffirmed your obligations to uphold the Constitution of the United States. And I understand you had an exchange with Senator Murphy on the Abrego Garcia case. And so I'm just going to put the question directly to you. Are you or DHS doing anything to comply with the 9-0 Supreme Court order to facilitate his return to the United States? Just yes or no.
Now, this administration is following all federal court orders.
Madam Secretary, this is a simple question.
It's the president's prerogative on conversations that happen with the president of El Salvador.
I ask a simple question. We have a limited amount of time. I just asked you, Madam Secretary, whether or not you or the Department of Homeland Security are taking any action to facilitate the 9-0 Supreme Court decision to facilitate his return. This is a very simple question. Are you taking any action to facilitate his return, or are you not?
This administration is following and complying with all federal court orders to make sure that we
So you are, because the court ordered that you facilitate his return, so you are facilitating his return.
Sir, Senator, thank you for the question. But what I would tell you is that we are following court orders, and that your advocacy for a known terrorist is alarming to me.
Madam Secretary.
It's alarming to me because he's a human smuggler.
Madam Secretary, I'm going to have to reclaim
and a terrorist, and he's not a U.S. citizen. He's a citizen of El Salvador, and he's home. If he were to come back here, we would take him immediately.
All right, I'm going to have to, Madam Secretary, you should know a couple facts then, which is, number one, in 2019, the immigration court said that he should not be returned to El Salvador because it would put his life in danger. The Trump administration at the time did not appeal that decision. After that, he got a work permit and was working legally in the United States of America. This is also why the district court and the appellate court and the Supreme Court have ruled as they have. I suggest that rather than make these statements here, that you and the Trump administration make them in court under oath, because despite what you just said, the federal district court, whose judge is hearing this case right now, said, and I'm quoting, that the administration has provided no evidence linking Abrego Garcia to MS-13 or any other terrorist activity. I'm not vouching for the man. I'm vouching for his due process rights.
Yes, you are, sir.
No, Madam Secretary, with respect.
I would suggest that you defend and stand alongside the victims of illegal crime.
This is political rhetoric.
Citizens who live here and are United States Americans. I would suggest you advocate for them as hard as you do.
Madam Secretary, I know you're doing a political speech here. I get it. I'm asking questions of law. No, you're just spewing rhetoric.
I truly believe this.
You're spewing rhetoric. Let me ask you this. Do you agree with Justice Scalia in the Supreme Court opinion in Reno v. Flores that, I'm quoting, "It is well established that the Fifth Amendment entitles aliens to due process of law in deportation proceedings." End of quote.
Sir, we are utilizing every due process tool that this Congress has afforded us. The Congress decides what due process is appropriate for every situation. Expedited removal is a due process that you have afforded us that we are utilizing. The Alien Enemies Act.
I'm going to reclaim my time, Madam Secretary.
So we are giving due process and using the tools that this Congress has given us.
This is really, I'm asking sort of simple questions of law. And simple questions like, are you complying with the 9-0 Supreme Court decision? And you seem to think that's some kind of trick question. Let me ask you this. You were down at CCOT in El Salvador, and you said, and that, I'm quoting, "It is one of the tools in the toolkit that we will use." And it's well known that the Trump administration is paying the government of El Salvador to keep these individuals, including those who the U.S. courts have determined were illegally taken out of the country in violation of their due process rights. Have you seen the grant document between the United States and the government of El Salvador with respect to the CCOT?
It's important that everybody knows the consequences of what happens for their actions in this country. When you break the law and you're a member of a foreign terrorist organization,
I asked you a question. Have you seen the document? This is not hard.
Yes, I have.
Okay. And what are the provisions of the document? So do you know what entities in El Salvador are receiving the funds?
I'm sure you can see this document as well and have looked at it for evaluation.
I'm glad you raised that, Madam Secretary, because I sent you a letter along with many of my colleagues here on April 8th asking for, among other things, that document. Will you respond to the letter that we sent?
I will respond to your letter.
Can I get some sense of when?
We will take a look at it. I don't remember seeing your letter yet, but I will certainly take a look at it.
Well, it's been there over a month.
The senator's time has expired. This exchange between Senator Chris Van Hollen and Secretary Kristi Noem isn't just tense because of tone. It's tense because it exposes a fundamental conflict between constitutional law and political messaging. Van Hollen begins with a deliberately narrow question, not whether Kilmar Abrego Garcia is innocent, not whether he's a good person, not whether immigration enforcement matters. He asks one thing: is the Department of Homeland Security taking any action to comply with a 9-0 Supreme Court order directing the government to facilitate Garcia's return? That framing matters. A unanimous Supreme Court ruling is not ambiguous, it is not partisan, and it is not optional. Noem's response immediately avoids the legal core of the question. She repeats a familiar phrase: "We are complying with all federal court orders," but never explains how. Instead, she pivots to rhetoric, accusing Van Hollen of advocating for a known terrorist. That accusation is doing a lot of work here, because once the conversation is reframed around terrorism, due process becomes politically inconvenient. Van Hollen pushes back with facts the administration doesn't dispute in court. An immigration judge ruled in 2019 that Garcia could not be deported to El Salvador because his life would be in danger. That ruling was not appealed by the Trump administration. Garcia was then issued a work permit and lived legally in the United States. Those facts matter because they explain why every court that reviewed this case, district, appellate, and Supreme Court, ruled against the administration. And that's when Van Hollen makes the most important clarification of the entire exchange. He says, plainly, "I'm not vouching for the man, I'm vouching for his due process." That distinction is the heart of constitutional governance. Due process does not depend on popularity. It does not depend on citizenship status, and it does not disappear because an administration labels someone a criminal on television. Van Hollen reinforces this by invoking Justice Scalia, not a liberal icon, but a conservative constitutionalist, who wrote that the Fifth Amendment guarantees due process to aliens in deportation proceedings. This is settled law. Noem responds by pointing to expedited removal and congressional authority, but again avoids the core issue, a Supreme Court order specifically directing the executive branch to facilitate a return that DHS claims it cannot or will not carry out. The tension escalates when Van Hollen raises El Salvador's detention facility, CCOT, and confirms that U.S. taxpayer funds are being used to hold individuals, including some whom U.S. courts have already ruled were removed unlawfully. This is no longer abstract. It's about whether the executive branch can outsource detention to a foreign government to sidestep constitutional obligations. When Noem admits she has seen the grant agreement but refuses to explain its provisions publicly, despite ignoring congressional letters requesting that information, the accountability gap becomes impossible to ignore. This exchange reveals something bigger than immigration policy. It shows how easily constitutional compliance can be reframed as weakness, how court orders can be treated as talking points, and how due process can be painted as defending criminals rather than defending the rule of law itself. For Americans, this moment raises a simple but unsettling question. If a unanimous Supreme Court ruling can be blurred, delayed, or rhetorically attacked, what does compliance actually mean anymore? If due process only applies when it's politically convenient, is it really a right at all? Watch this exchange carefully, share your perspective in the comments, and let us know where you think the line should be drawn between enforcement and constitutional limits. If this analysis helped you see something new, like, subscribe, and share so more Americans can follow what's really happening.